All right. So as John said, I'm employed by the University of Missouri Extension. I'm the County Engagement Specialist in Carter County, working in the areas of community and economic development. And I bring my past experience of practicing law with me into this position. John and I have worked together on several caregiver conferences in the past, and also trying to establish some different caregiver support groups. And so I always love the opportunity to try to meet with people who are in the thick of this, who are in the trenches, so to speak, and you need some information, you need some help sorting through this mess. I was jotting down as you all were kind of making your introductions, the phrases that you all are using to describe the court system: frustrating, complex, slow, deplorable. Those things are breaking my heart, but unfortunately, I can't disagree with a single one of them, because the court process is all of that and more. I am glad to hear that there have been some really good experiences, and I'm hopeful that today the information that you learn will help get you to a place where you're able to have the information that can help you get a good experience. I do want to make sure that we cover some vital information, though. The presentation today is not legal advice. I am not here in my capacity as an attorney. So the information that I present to you today is not me giving anyone legal advice. It also does not establish an attorney-client relationship between anyone in this group and myself. Even though I still have my law licenses, I am not here today really as an attorney. I am here to present some general information about how this process might go, to try to answer some questions for you all. And as always, if you have questions about your specific case, you need to consult with an attorney of your choosing, so that they can really assess the likelihood of your success based on your specific facts. All of these cases, as you might imagine, are very fact specific, and no two cases look the same. And so it's very important that you get accurate legal counsel from an attorney about your specific situation. But we do want to give you some general information, and we're talking today about custody conundrums. I mean, the reality is we can really end up in some messy situations when we are the caregiver for some children. And so today we're going to talk first about the two different types of custody that you could have. And then we're going to transition into what are the ways or the avenues that we can obtain the legal authority to be able to meet the needs for the children who are in our care. And so we are going to start by looking first at the types of custody. So you may have heard in times past someone say, well, I have full custody, or I have primary custody. And several years ago, those were the terms of art that were being used in the state of Missouri. That was very common. However, the legislature thought, gosh, that's still really pretty confusing, and I feel like maybe we need to simplify this a little bit. So now we hear different terms. The Missouri law now splits custody into two different types. One type is, if I can get my slides to advance, physical custody. And so we'll talk about that, and we'll also be talking about legal custody. And so those are the two different breakdowns of how custody is distinguished and defined in Missouri law. Physical custody is exactly what you might imagine. It's figuring out who's going to provide the physical care and control of a child. Who's going to be doing things like providing the food and the clothing and the shelter, and keeping a roof over the kiddo's head, keeping their belly full. Now, the thing to remember about physical custody is that that can be awarded jointly or solely. You will often hear joint or sole related when you're dealing with parent versus parent type of custody cases. When you all as caregivers are dealing with custody, you're usually looking at another avenue, and you're normally receiving sole custody, physical custody, when you're awarded custody, more often than not. That could be a different circumstance, but it's very, very rare. Most of the time, when you as a caregiver and not as a biological parent get a custody order, you're serving as a sole custodian at that point. Agencies can also be awarded custody, physical custody of a child. And a good example of this is Children's Division. They are very frequently awarded physical custody of minor children, but it could also be something like the Department of Health and Senior Services, Department of Mental Health, Division of Youth Services. All of those types of agencies can be awarded custody as well, physical custody. Legal custody is a little bit different. You know, with physical custody, we're talking about the person of the child, keeping the belly full, keeping the clothes on their body, keeping the roof over their head. Legal custody shifts that focus just a little bit and starts looking at how do we decide about the welfare of this child as a whole. And so we're looking as a legal custodian about making decisions about healthcare, education, religious upbringing, participation in extracurricular activities that would be beneficial or not beneficial to a child. We're looking more at the overall welfare when you're looking at legal custody decisions. Much like physical custody, legal custody can be joint or sole, and agencies can also be awarded the legal custody of a child. So they're very similar in that respect. Now, we have to sort of start with the basic premise, though, that parents are the natural guardians of their children. The United States Constitution, the Missouri Constitution, they all establish that the parent has a right to raise their child and rear their child in the way that they feel is appropriate. And it's very difficult to get over that hurdle of that constitutional premise. You have to have some pretty substantial showings in order to do that. So parents are serving as the natural guardians or custodians of their minor children. Obviously, that's going to include mothers. It's usually pretty easy to tell who is the mother of a child. She is normally the one who has birthday child, and she's, you know, normally the tired-looking lady trying to corral the kids, right? But that's not always such an easy determination. We live in a day and age now where there are a lot of reproductive options, surrogacy, embryo donation. There are a lot of options, and it may not always be so easy to determine who is the natural guardian of a child, who is the mother. But for the most part, it's pretty easy to tell who the moms are. Legal fathers, not so much, right? And so when we're looking at legal fathers, that's a whole different story. And fathers and mothers are not really on the same footing when it comes to the custody determination. The only natural custodians are legal fathers. And so you may think to yourself, well, a dad is a dad, and so, you know, aren't all fathers legal fathers? And the answer to that question is no, they're not. Legal fathers have specific requirements in the law in order to be considered a legal father. And so I hear often, or heard often in my law practice, well, he's on the birth certificate, so, you know, it's fine. Well, unfortunately, he might be on the birth certificate, but that doesn't mean the law considers him to be a legal father. Being on the birth certificate is what they call a presumption of paternity, but it is not an establishment of him as a legal father. Now, you may go a step farther. You may say, well, he had a DNA test, and it was 99.9998% likely that he was the biological father. So there you go. He's dad. Again, DNA testing is not a legal determination of fatherhood or paternity. It is a presumption. And so you go, okay, so if being on the birth certificate doesn't do it, if getting a DNA test doesn't do it, how in the world do you know who is the legal father here? And so Missouri law tells us that legal fathers are those who are married to mom at the time of their birth, at the child's birth. And so husband and wife situation, if they're married at the time of the birth, that father is a legal father. If a child is born within 300 days after the marriage ends, and you think, gosh, when would that ever happen? Well, I'll tell you a real life example. My dad was married before he married my mom, and he and his first wife got a divorce in April. They didn't realize that she had gotten pregnant in March. And so they got their divorce. Everything was fine, no big deal. And then about a month after their divorce is final, she realizes, uh-oh, we have a really big problem here. And so along comes my sister, born in December, which is clearly within 300 days after that marriage ended. And so the way that the law treats that, my dad was the legal father. Well, okay, but what if he really hadn't been? I mean, there are conceivable possibilities that, maybe there was another person in mom's life, and it's possible that my dad might not have been the actual biological father, right? Now, of course, when my sister came out, there's no doubt she's my dad's kid. She looks like my dad, acts like my dad, she's my dad made over. But it's possible, but the law doesn't seem to make any differentiation for that. They treat that father as though he's the legal father. And if he believes he's not, the burden is then on him to go back into the court system and take legal action to prove that he is not, in fact, the father, and get, for lack of a better word, off the hook for that. So it's a little bit different there. The other possibility that makes someone a legal father is they were never married to the mother, but they were declared by the court to be the legal father. And so we find this come up in paternity cases, what we call paternity, where someone goes to the court and says, we were never married, but we need to declare this guy dad, and we may deal with custody, we may deal with child support, we may deal with a lot of things in connection with that. But step number one is to have the court declare this man to be the biological father of the child. And they often refer back to things like, is his name on the birth certificate? Has there been DNA testing? Those things, again, are presumptions of paternity that help the court make this legal decision, but it has to be that legal judgment from the court in order for him to be considered the legal father. So you're not maybe the natural custodian. You're not mom, you're not a legal father, but yet here's a kiddo. And so where did this kiddo come from? Pardon me, I got strangled on my spit. So we look at a couple of different possibilities. One is the parent can actually place their child with someone, and this happens a lot, okay? Someone brings their child to you and says, man, I've got a lot going on right now. Can you keep my kiddo for a few days? Okay, fine. And then a few days turns into a month, and then maybe a few months, and maybe a year goes by, and you still have this child. So that's one of the ways. Another way is if a parent drops this child off with someone else, and then that person in turn says, here, I don't want to do this anymore, or I can't do this anymore. I often saw this play out where a biological parent had left a child with a grandparent, and grandparent was fine to do that in the short term, but when it became a long-term situation, maybe grandparent felt that they were too elderly to do that, or maybe they had health concerns. They just weren't able to do it, and now suddenly maybe auntie gets called up to the big leagues, and now it's auntie's responsibility, and she takes this child in. And so those are some ways that placement by a parent can happen. But we can also have placement by agencies. We're looking at things like placement by the court. The court has the ability to place a child. I want to take a step back, and when we're looking at placement by an agency, maybe the bigger issue that we should be looking at is who has the ability to remove the child. The court certainly has the opportunity and the authority to remove children if the situation warrants. They can say, it's not in the children's best interest to stay with the parents, we're removing this child. The juvenile office also has the authority under the statute to remove a child. So if they become involved, they can come and remove a child, and they can place temporarily, but they do have to follow up with a court hearing called a protective custody hearing that has to be held within 72 hours of the removal, and then the court has the say-so to determine the placement options at that point. Similarly, the statutes give law enforcement the right to remove a child if necessary, if the situation warrants it. And finally, we sometimes hear people say, well, this child was placed with me by Children's Division. And this gets a little bit trickier because Children's Division actually does not have the statutory authority to remove a child from a parent. And you go, wait a minute, that doesn't make sense. If I call in a hotline, who answers that call? That'd be Children's Division, right? Who investigates that call? Well, again, it's Children's Division. They're coming out, they're looking at the situation, and if they come out and they find this child needs to be removed, don't they just pick that kid up and go? Well, the answer is no. They either have to be accompanied by law enforcement or they have to be accompanied by a juvenile officer, and those entities are the ones who technically do the removal. Now, once the court intervenes, they can vest custody with Children's Division, and Children's Division can then place. Now, I can see in my head the wheels that are turning for some of you. Some of you are going, nah, that's not right, because Children's Division placed with me and gave me a safety plan. And I heard that very, very, very frequently when I was practicing. But what you have to understand is that a safety plan is not a court order. They certainly exist, but they are not a court order. A judge doesn't see those, a judge doesn't sign off on those, and they're not binding. Furthermore, it doesn't trump an existing court order. So if there's already a custody order out there somewhere between maybe mom and dad, and Children's Division enters into a safety plan with you all, it doesn't trump that previously existing court order. So safety plans, they exist, but they don't always do quite what you think they're going to do. Safety plans exist for Children's Division to be able to try to prevent removing a child completely from the parents and pulling that child into the system, into the state care. That's what safety plans are for. These are not designed to be long-term solutions to a problem. They are designed to be very stopgap measures. And so if you are dealing with a safety plan, it's basically an agreement between Children's Division, the biological parent, and you as the potential caregiver that says, hey, we're voluntarily entering into this agreement, but it is not a court order. And that's something that you do need to understand. So we're going to take just a quick little quiz just to sort of make sure we understand what we have talked about so far. And I know that you all have been doing this Zoom thing for a while. And so what we're going to do is we're going to do this with the chat feature rather than making it complicated and having everybody unmute and give an answer. We're just going to throw it up in the chat. I'm going to give you 5 choices to answer on this question, and you can just throw the letter of your choice into the chat feature. And if John or one of the Parent Link ladies would kind of just give me a shout out about what we're seeing, that would be helpful. Well, that's not what I wanted to do. There we go. All right, so our question is, a legal custodian can make which of the following decisions regarding a child? Number 1, or option A, they can decide where a minor child attends school. Option B, they can decide whether a minor child receives a vaccination. Option C, whether a minor child participates in extracurricular activities. Option D, all of the above. Or option C, or E rather, none of the above. And so I'll give you just a quick minute to throw your answers down into the chat. Just taking a quick look at that.
Looks like most of your answers are D, is what people are choosing.
Yeah, that's what I'm seeing too. All right, and so actually our correct answer is in fact D, all of the above. Because remember, our legal custodian is the one making decisions about the overall welfare of the child. And so very much where this child's attending school falls into that. Whether or not this child receives particular types of medical treatments, such as a vaccination, very much falls into that. And whether or not they participate in extracurricular activities, also very much a part of that. So yes, that is absolutely correct. Now, we've talked about the different breakdowns of custody. I want to shift gears and go very quickly through what are the avenues that we use that get us the authority to take care of these issues for children that are in our home. And we're going to go from the maybe least permanent or least secure to the most secure. And so we're going to start by talking about the temporary delegation of parental authority. And man, is that a mouthful, right? You need to understand that this is a document that is prepared by an attorney. It actually does not ever go in front of a judge, never gets approved by a judge or signed off on by a judge, but a lawyer drafts this document and a parent signs it and says, I'm temporarily giving you the ability to stand in my shoes to provide certain levels of care for my child, okay? There are some limitations with this document, though. The first limitation that you should really be aware of is that it expires after 1 year. That is in the statute, and it's very clearly written. There's no exception for that. 1 year from the date that document is signed, it is over, and your authority under that document is over. And so, you know, that's sometimes difficult because, I mean, come on, how quickly does a year pass? I mean, obviously not 2020 because 2020 is never going to end, but any regular year, how quickly does that pass when we get busy and we're doing things and having to worry about other issues? All of a sudden, a year's gone by and you think, oh, holy cow, I don't even know where this parent is anymore. I don't know where they're at. How do I get hold of them to get them to try to sign a new one of these? It could really become a problem because what if the child that's in your home has some sort of medical emergency? You take that expired power of attorney up there to the hospital, they're probably not going to honor that. And so now we really have a big problem. We have a child that has no one there to provide that care. The other really big issue with this is that it can be revoked by the parent who signs it anytime. And so you can probably well imagine the very first time a parent gets mad at you because they want to come see the kid in the middle of the night and it's going to mess up that child's routine, or you know, they want to come over while they're under the influence of something and you won't let them see their child. The first time that parent gets mad, they can tell you, hey, look, I'm revoking that. You no longer have any authority to take care of my kid. I'm taking my kid back. And the reality is that if they do that, law enforcement is probably going to be on their side, and they're probably going to tell you, hey, look, we can't intervene. If they're revoking that power of attorney, there's nothing we can do. And so that is a really, really big limitation for these temporary powers of attorney. A couple of other minor limitations that you might see is that the parent can't delegate all of their power to someone else. For example, they can't delegate the power to consent to that minor child's marriage. So, you know, if you do this power of attorney, I give John a power of attorney for my child, he can't turn around and consent that that child can go get married if they're underage. Same with the minor child's adoption. And obviously that's a good limitation. We don't want to give someone a power of attorney and then them turn around and sign a consent saying we're okay with them being adopted. So these are very limited in their scope. It's really, again, this is a stopgap measure. This isn't intended to be something permanent. It's intended to fill in the gap in a pinch. So this is not something that I ever really recommended often to clients when I was in practice, but there are some situations where it might really be applicable. Might be applicable for an older child that's maybe 17 and the choice is, you know, something's gone wrong at the parent's home and they either come into care into the state system or somebody does this power of attorney. In that case, it might really be appropriate because the expiration date's not going to be a big deal. You know, kiddo's going to reach the age of majority before it expires anyway if they're already 17. So this might really fit in that circumstance, but most of the time, maybe not an option to do here. Legal guardianship is obtained in the probate court. Now, this is a little bit more secure than that temporary delegation of authority. And our guardianship requires the court to find that the biological parents are unfit, unwilling, or unable to carry out their obligations as the parent. And the burden of proof is on you. So if you are grandparent or auntie or uncle or friend of the family or whoever is taking care of this child, and you come to the probate court to file this guardianship, you have to prove that those parents are unfit, unwilling, or unable to serve their parental obligations. It is important to realize that guardianship does not terminate or sever that parent-child relationship, though. So basically what a guardianship does is it tells the parents, hey, look, we recognize your authority as the natural guardian, but what we're going to do is we're going to put in this guardian, and their authority is going to supersede yours. It doesn't cut you off, but their authority just supersedes yours until we amend this order. And as the guardian, you are awarded the legal and physical custody of the minor child almost always. There are some exclusions to that, but most often you are awarded the legal and physical custody. But the court may allow those parents some visitation with that minor child. They can make that part of the court order when they grant your guardianship. So it doesn't necessarily mean that you won't have to deal with the parents in that capacity. The guardianship's going to remain in place until either that child turns 18, and that's when they've reached their age of majority, or until that guardianship is set aside or terminated in some other way by the court. And when that happens, that natural parent who had those natural guardianship rights over their child, your authority as guardian goes away, and that natural parent is restored to those rights that they had already had under the Constitution. Okay, so I want to take a minute and just sort of talk about pros and cons here of guardianship. There are lots of reasons why this might be a good option. It certainly achieves some level of permanency for the minor child, which is good. Once that guardianship is in place, it has to go back through the court in order for anything to change with that. The other thing is that the longer that guardianship remains in place, in other words, the longer that child is in your home subject to that guardianship, the harder it is going to probably be for the biological parents to come in and set that aside and ask the court to overturn that. Because courts are looking at what's in the best interest of this child. Do we really want to let this kid spend years and years and years in the home of this guardian and bond with them and have all of that stability and then have that yanked out from underneath them when the parent's back on track? That's a really fact-specific finding that the court has to make, but you also have to balance that with the reality that the intention for why these guardianships exist is that these are not intended to be permanent. There is a reason it doesn't sever the parent-child relationship. The whole idea behind this is that the parents will eventually get on track and be able to parent their children. And so the courts really have to balance that legal principle against, hey, we've also got to protect the best interest of the child. And again, that's a very fact-specific inquiry that the court has to determine after hearing all of that evidence. The cons, kind of the downside to guardianship, is that they're expensive. The power of attorney, the cost of that varies from attorney to attorney, but you're probably looking at less than $200 to get an attorney to draft that. Guardianship, however, because it is a court process, because it requires specific things to be proven by law, again, the price varies from attorney to attorney, but it could be anywhere from $1,500 on up. I've seen guardianships be as expensive as $5,000 sometimes when the parents wanted to come in and fight you about that. And so that process can be really costly, and that is a downside to the guardianship. It's also a downside because the parents can bring you back to court pretty much anytime the child is still a minor. If they think that they've got their feet under them and you don't agree with that, they can bring you back to court, and then you have to pay an attorney to defend you through that process. And maybe you're going to prevail and remain the legal guardian, but you've now had to spend even more money to keep that in place. So there are definitely pros and cons to that, but it does give a little bit of security over and above what that temporary delegation of authority does. It's also a little bit more beneficial because parents might agree to this more easily. because it doesn't sever their biological relationship or their legal relationship with their child. And they may also be more willing to agree to it because they can, in fact, get court-ordered visitation. That is a really recent change to the law. I'd say within the last 2 years that's been changed. Before that, courts said, hey, this is a guardianship, and when I name a guardian, you got to work it out with a guardian. And so then that biological parent had to rely on you as the guardian doing what you should do for the best interest of a kid and deciding how much, if any, contact is appropriate. Now the courts can decide that in advance, and this parent has enforceable rights to have time with their children. So they may be more likely to agree to this, which may help you get a parent on board with this maybe a little bit more easily. All right, so now we're going to shift gears and talk about third-party custody. This is actually really similar to the guardianship that we've looked at, the guardianship option, but it's going through a different court. This is obtained in civil or family court. Different counties call it different things. Here in Butler County and Carter County, it's called civil court, but in the more metro areas, I think they have family courts. Third-party custody requires a specific finding that the parents are unfit, unsuitable, or unable to be the custodian, or that the welfare of the child so requires the appointment of a third party. And so I've listed the statute there for you if you want to take a look at that. And so you think to yourself, unfit, unsuitable, unable. Okay, yeah, well, that might be, maybe I can prove that, maybe I can't, but the welfare of the child requires, I mean, my gosh, that should be easy to prove. I'm clearly the more secure placement here. But the reality is the case law that has come down, further explaining and dealing with this statute has made that a little bit more difficult. So it's not as clear cut. Again, this third-party custody option is extremely fact-specific. And so it's not a cut and dry thing any more than any of the other options are. But a third-party custodian can be any other person other than the parent deemed to be suitable and able to provide the adequate and stable environment for the child. So again, this third-party custodian doesn't require that you be a relative of the child. It can be any other person that could be suitable and able to provide that stable environment. Third-party custody, the statute says that it's basically a last resort. And I'm getting a message that my internet connection's unstable, so if you have problems, let me know. It's a last resort. The statute says all of the other combinations of legal and physical custody have to be considered first. So in other words, the court has to consider whether one parent is suitable for sole custody. They have to consider that before they'll consider a third-party custody. So basically what that means is the court has to say, look, both of these parents are so bad that we have to bring in a third party to have custody of this kiddo. And the civil courts, they're not really used to doing that. That doesn't happen as often as you might think. And so it really is something that is a bit more challenging to accomplish in that civil court. Third-party custody, much like the guardianship, it remains in effect until the child becomes an adult or until it's modified by the court. This also does not sever that parent-child relationship, and a parent, similarly like the guardianship, could be awarded visitation with that minor child. And so you may ask, well, what's the difference? Why would I file guardianship or why would I file third-party custody? When would be the appropriate time to do that? Guardianship is usually something that's filed when there's no other court case going on. There's not usually anything else happening. But the third-party custody normally comes up when mom and dad are already in a custody proceeding themselves. And so when that happens, if mom and dad are already in court trying to fight it out and things are going awry and both of them are kind of falling off the rails, you can come in then as a third party in that case. You wouldn't want to have that case going on and then bring in this second case, this guardianship, when you could accomplish the same thing by jumping in their case. And so that's sort of the difference between these two. Other than that, they work very similarly with each other. They're also pretty comparable in cost usually for attorney's fees and those sorts of things. And so there's not really a significant difference there either. We have a question?
Yeah. She was definitely from that old.
Okay. All right. So the last option that we have to have an avenue for obtaining the custody or authority that we need is adoption. And this is the most permanent of all the solutions. It's obtained in juvenile court. So you understand we're going to a different court for each of these avenues. And that's part of the reason why so many of you said, gosh, this process is complex and it's frustrating and it's overwhelming and it's confusing. I can see why. You're in a different place for so many of these options. This action does terminate that parent-child relationship, completely severs it, and that natural parent is treated as though they did not exist in that child's life, according to the law. And what it does is it then treats you as the adoptive parent as though that child had been born to you all along. And so this is a very, very permanent solution. It can't be set aside. It can't be terminated. It's very, very permanent, which means it gives that child a whole lot of stability. But the flip side of that coin is it comes with a higher burden of proof. The burden of proof is on you as the petitioner to prove that you meet one of the grounds for adoption. And so let's talk about what those are. We're talking about grounds for adoption, and the first one that the statute mentions is that the biological parent's rights had been previously terminated. If you can say that, because maybe let's say the child came to you as the result of having a juvenile case, and in connection with that juvenile case, they've terminated the parent's rights and then cleared you for adoption. In that case, you can go right on ahead and that's your grounds and you've met it. The biological parents could have previously consented to the adoption, okay? And so if they've already agreed to that, you've met a ground. The biological parent's identity is unknown and can't be ascertained. Now that seems kind of odd. You think, gosh, when would that ever happen? But it actually does happen, especially with fathers. It could be that a mother was sexually abused. It may be that a man misrepresented himself and about his identity. Lots of reasons why dads might not be able to be ascertained as to their identity, but even moms. Here in Missouri, we have safe haven laws for mothers who want to abandon their babies in a safe place because they don't think they're capable of raising a child. And if that happens, it's an anonymous process. And so that mother's identity may never be known. So it does happen. It's just not very common. A man who is not established as the father denies paternity. I've actually never had this come up in 8 years of practice. So I can't even really give you a for instance about this. But the example that I could foresee is, you know, a mom names him as dad and he says, no, I'm not the dad. I don't have any intention of claiming this child or holding him out to be mine. You don't have any reason to believe I'm the dad. I didn't have a relationship with her. I'm not the dad. And in that case, that's a grounds that you could establish under the adoption. That the biological parents were served, but they are in default. So in other words, if the parents have been provided notice that you have filed this adoption proceeding and they don't come back into the court and make any written objection to it, they don't come and participate in any of the court proceedings, the court can go ahead and grant the adoption if they don't come in and participate. The biological parent has a permanent but incurable mental condition that renders them unable to parent. So this might be a permanent mental illness that, you know, most mental illnesses are treatable, but sometimes they're not. And so this ground may be met with something like that. But the most common is that the biological parents have abandoned the child. Chapter 453 of the Missouri statute talks about what constitutes abandonment. And the standard is different depending on the age of the child. If the child is less than a year old, The only abandonment you have to prove is 60 days. If they haven't had a relationship, haven't had contact, haven't supported that child for 60 days, and that child's less than a year old, that ground's been potentially met. Over 1 year of age, the requirement is 6 months. And so you're looking at things like, have they had visits? Have they made phone calls? Have they sent letters or cards? Have they provided financially, either by handing you money or sending you money, or have they sent clothing or food or diapers or anything like that? And so that's a very fact-specific inquiry too for the court to decide. They also look at whether or not you as the caregiver has prevented that parent from having a relationship. And so they're not going to grant an adoption if the court thinks that you have interfered in that parent's attempt to have a relationship. So the best advice that I think you could get in connection with this and how to prove that would be to keep a journal. Keep a journal of the contact that the parent has with that child, the date of the contact and the nature of the contact, and just keep that going throughout that child's time with you. And when you get to that 6-month mark for a child over 1 year, or 60-day mark for a child less than a year, it's time to go talk to the attorney right away and get moving on that probably. So those are the grounds for legal adoption that you have to be able to prove, and the burden is on you. So we're going to do one last test your knowledge. How many types of custody do not sever the parent-child relationship? Now remember, we talked about the temporary delegation of authority. We talked about legal guardianship. We talked about third-party custody, and we talked about adoption. So we've got 4 different custody types that we've talked about here. How many of those types do not sever the parent-child relationship? Throw that up into the chat. Do not sever the parent-child relationship. Okay, looks like most of you are answering B. And that is correct. 3 of those custody types protect that parent-child relationship, and only adoption severs that. And that's absolutely correct.